Welcome everyone, this is Amer Mushtaq from Counsel. Today we'll talk about obligation to mitigate in employment law circumstances. It is an essential obligation in most of the employment law cases and it's a duty on the employee, the terminated employee, to try to mitigate his or her damages. So we'll talk about it, we'll explain what does it mean to mitigate and what is it that the employee needs to do. Before we begin, we will provide you with our usual disclaimer that this course is not legal advice, so if you have any specific questions, please contact your lawyer or paralegal. Let's begin with mitigation. What does it mean? And we'll talk about mitigation in its broad sense. Mitigation is essentially the reasonable action that a party, the aggrieved party, the party who has suffered any loss, must take reasonable action to minimize the loss that it has suffered. Let's explain that by way of an example, which will make it easier. Assume that you had a car and you were trying to sell that car, you were leaving country or you were transferred to another province and you had to sell that car and there was a time crunch that you needed to sell that car. So you get into a sales contract with someone who is interested in buying your car, you come to an agreement and the person is willing to buy your car, let's say for $20,000. You have set a date and time when the person will come and give you a check for $20,000 and take away the car, and based on that you refuse any other offers that other parties that may be interested in buying the car from you, and you turn them away because you have already entered into a contract. And for some reason the person who has entered into contract with you does not fulfill the contract, does not pay you the money, basically ignores the contract completely. So if that's the case, then you have suffered a loss of $20,000. Your damages, your loss is $20,000 because you have a valid contract which is not being enforced. So what does the law ask you to do? The law asks you to try to mitigate your damages, and in this case, how would you mitigate your damages? You will try to sell that car to someone else within the time frame that you may have. So let's say if you are on a time crunch, you only have a day left, and you put your ad on Kijiji or in the newspaper, and then you eventually are able to sell the car for a loss, and you sell it for $15,000. So your damages really are now $5,000 against the person who had entered into contract with you for $20,000. So this is what you have done. So your initial damages were $20,000, and then you took steps to sell the car to someone else because the law says you have to try to mitigate those damages, and you were able to partially mitigate, meaning out of $20,000 you recovered $15,000 and the loss is $5,000. Now imagine that if you were able to sell the car for $25,000, then you actually have no losses against the party that you had contracted against. So you were able to fully mitigate your damages. So even though the other party breached the contract, there are no resulting damages. You're not entitled to any money if you were able to recoup all of your losses. So that's what mitigation is, and that's what it does. It tries to, in a way, help the party who has actually breached the contract by imposing on you to try to minimize your damages. In employment law context, what does this mean? In most of the wrongful dismissal cases, the duty to mitigate arises because in most of wrongful dismissal cases, what you are doing is what you are telling the court, what you're asking the court, that you have suffered loss or damages in the amount of X amount of dollars, $20,000, $100,000, $200,000, because that was the termination pay, severance pay, reasonable notice that you were entitled to that the employer did not provide. So in that case, the law imposes an obligation on you to try to mitigate those damages. So if the damages were $100,000, the court imposes a duty on you to do certain things so that the damages could be reduced from $100,000. So that's what is an obligation to mitigate in employment law context, and I will talk about how you go about doing this. One note that you want to keep in mind is that the obligation to mitigate in employment law does not arise in every single circumstance. There are some specific circumstances where you don't have an obligation to mitigate. Those are very few circumstances. It is not common, so you must contact your lawyer and figure out whether you have an obligation to mitigate, and if you do, then you make sure that you fulfill that obligation. So what do you do in employment law context to mitigate your damages? Essentially, you make efforts to look for another job, right? That's how you will mitigate, because your damages are employment damages. your previous employer refused to give you salary for X amount of dollars for X amount of months. So the way you can mitigate is by working for another employer for X amount of months for X amount of dollars, and that's how you can mitigate. So what are the things to keep in mind? The obligation to make an effort, the court requires you to make reasonable efforts. And what does that mean? If you are, for example, based in GTA, in Toronto or in GTA, and you are working in GTA, the law does not require you to go look for a job in Alberta or Saskatchewan just because you have an obligation to mitigate, because that will be considered unreasonable. So you don't have to fetch every single job that is relevant to you around the entire country. So reasonable efforts are required. And then the second part that you want to keep in mind is that you have to look for a comparable job. So what that means is comparable to the previous job that you had at the former employer. What that means is, example, if you were a manager of accounts and you have to look for a job, you are not required to apply for jobs as a cashier at Walmart or McDonald's, because that's not a comparable job. So comparable in terms of the duties that you had, and also comparable in terms of pay. So if you were making $100,000 at previous job, the law does not require you to go look for a job which pays you $75,000, right? So it doesn't have to be a match for a dollar to dollar, but comparable. So if you were making $100,000, $90,000, even $85,000 may be considered comparable, but anything less than that may be considered, not comparable. So you make reasonable efforts to look for a comparable job. And final point is very, very important. You must keep full records of all of your activities. And so what that means, one, that you must keep sort of a summary, a log of all of the activities that you perform in your efforts to mitigate your damages. And then you keep all the corresponding evidence. So if you have been sending emails, you must keep record of those emails. If you have been sending letters, faxes, phone calls, you must keep evidence, because this matter may go to trial and you may have to prove that you actually made those efforts. So your word alone is not sufficient. You must prove this with evidence that you actually make those efforts. So let me give you an example of how do you go about making those efforts. So here is something that we ask our clients to look into with respect to job efforts. So let's say we usually give them this copy of the spreadsheet and say you want to make sure that you are following this. So this is sort of a Excel spreadsheet. There are multiple columns and a date, so you want to make sure that what date you are performing that activity. If you're looking for a job at a search engine, let's say Indeed or Workopolis, or at a specific company website or through a recruiter, you want to document that, the name of the person that you contacted, phone number, email address, what industry you are looking for that job, what was the title of the job, was it a full-time job, part-time job, all of these things that you want to look at. Then what was the annual salary? Let's go back here. So what was the income that was being offered? What was the location? How did you apply? Did you send an email? Did you call? Did you attend in person? How many job postings did you review? How many postings did you actually apply? These are some of the things. And then what was the outcome of these job searches? So did you get any interviews? Did you get any callbacks? Whatever the response was, you want to document that. So this spreadsheet is a summary. It creates a log for you, which you can review. The lawyers can review, the opposing counsel can review, the judge can review, the mediator can review, and have a summary before them that shows them what kind of activities that you have performed. Now, you must keep the corresponding evidence. So if you send faxes or emails for anything, you must keep those faxes and emails, and because that is actually what is evidence, and you must prove to the other side that you actually performed those activities. So that comes to in terms of the jobs activities. And so what do you want to remember is that, first of all, you want to make sure that you confirm with your counsel, or make sure that you are required to mitigate or not, and you find this out early on. You don't wait for a few months or midway through your court action. You must know this from the outset of your case. And most lawyers, and it is our practice in our law firm, that the moment we are retained, we send a detailed memo to our client basically explaining to them how what is mitigation, how they're required to mitigate, and how do they keep records of that. And then you make sure that you make reasonable efforts to mitigate, and then you keep full records. I'll give you a quick example of what mitigation entails. So I recall one of our clients, she lived in St. Catherine. She worked for a video store as a manager. The entire store closed down. There were no comparable jobs available. She had very limited jobs in her area. And so based upon her skill set, the comparable jobs that were being posted in her area were either none or minimal. And so part of our mitigation effort was that she will look at the newspapers on a daily basis and find that there is no job that she could apply, and then just keep records of those newspapers. And at mediation, we had this bundle of newspapers with us, basically showing that every single day she went and looked for a job in the newspapers, amongst other activities. But and all of these newspapers are there to demonstrate that there isn't a single job that was comparable to her skill set. So that's another way. So it's not that you just need to prove what jobs you applied, but whatever activities you did, you looked for a job, you went online and you found nothing, you must prove that as well. And then everything you do, for instance, calling your friends or attending networking events or meeting recruiters, these are all activities that you are undertaking to mitigate your damages. So you must record all of that so that the judge, the mediator, the opposing counsel has a full view of what activities you undertook. Mitigation is an important obligation. You cannot ignore it, and so it's important that you have good records and it does not minimize your damages, because if you fail to mitigate your damages, the court can reduce your damages and in some cases completely negate any of the damages that you're entitled to simply because you failed to mitigate your damages. So hopefully this gives you a basic understanding of the obligation to mitigate in employment law context. If you have any further questions, please contact us. Any clarifications that you require, please let us know, and we'll be happy to add that in the future lectures. Thank you for watching.